Is this shit legal? I mean, we all want to know. We see Trump putting federal troops in D.C., L.A., threatening to do it in Baltimore, Chicago, and other major metropolitan cities. To answer that question, of course, I had to invite constitutional law scholar Steve Vladeck, friend of our show, friend of our channel, and generally an all-around amazing guy who has the patience and, frankly, the ability to be able to let us know really what we should be focusing on. And so here we go. Take a listen. And you've seen him on my Substack lives, but I had to have Steve Vladeck come and join me here at the Katie Phang News Channel on YouTube. Why? Because this is your channel. And as I always say, we want high information Americans, and there is no one better than Steve to get us into a smarter space. Steve, let's start with Washington, D.C., the federalization of D.C. I have covered it. We've talked about it, but frankly, I've cited to you as my source for an explanation of this. So, Steve, explain why it's legal, at least on its face, it's legal for convicted felon Donald Trump to federalize D.C. at this point.
Sure. I mean, so I think I will take one slight quibble with the word federalize, because I don't think that's what he's done. So, DC, Katie, as you know, is this really unique creature in our political geography. It's unique in that it's not a state, but it's also unique even compared to the other 5 inhabited territories, in that even though we have a local government in DC, our local government has less control than any other local government anywhere else in the country, including in, say, the Virgin Islands or Guam. And the two most important things over which the DC local government lacks local control are the National Guard and a lot of our sort of criminal prosecution apparatus. There is a DC Attorney General's office, but they only prosecute low-level misdemeanors and juvenile offenses. It's actually the U.S. Attorney who prosecutes all serious offenses, even those under local DC law.
Wait, I got to interrupt for a second because I want to remind people that the current United States Attorney for DC is box of wine, Jeanine Pirro. Please continue, Steve.
Which is still a dramatic improvement over Eagle Ed Martin.
True. Touche. I'll take it.
It's the world we live in. But so the last piece of this and what President Trump is really relying upon is a very, very unique authority that Congress preserved for the president in 1973 when it gave DC basically its modern local government. And that was a power not to take over, but to utilize assets within the Metropolitan Police Department for up to 30 days during a, quote, emergency, unquote, for federal purposes. And so, Katie, what we're seeing in DC, at least, I liked how you said it, at least facially, right, is the president relying upon 2 authorities, one about the National Guard and one about the DC police, that he doesn't have anywhere else in the country.
Well, let's start with the Metropolitan PD, because I do think the National Guard is an incredibly nuanced thing that's less legally problematic on its face. But the Washington PD stuff, I understand Section 740 of Home Rule allows him to do it, but nobody has defined for me what federal purposes means. Like, what does it mean to utilize assets from the Metropolitan PD for, quote, federal purposes?
Yeah, so there's legislative history on this, from when Congress enacted the Home Rule Act in 1973. Just to put this in context, I mean, let's remind people that when Congress created Home Rule in 1973, there was no local government in D.C., right? That from 1874 to 1973, DC had been administered almost entirely by a board of commissioners that was appointed by the president and that was overseen and administered basically by 2 powerful congressional committees. So, standing up a local government, it wasn't the first time DC got a local government, but it was the first time in 100 years. Okay. And the local government Congress stood up. Congress did not want to sort of denude the president of the power to protect the federal government. And so one of the things it preserved was this power to use the MPD. The federal purposes in the legislative history is very capacious, including, where necessary to, protect the residences of senior members of the federal government, right? Where necessary to ensure free flows of traffic, right, to federal installations.
But don't those things actually have to be at issue for him to be able to invoke that Section 740 power?
So herein,
none of
right,
that's happening, though.
So herein lies the rub. I mean, so the provision of the Home Rule Act that you're mentioning is one of the many statutes we are encountering here in 2025, in which Congress has given to the president the power to do something he's not otherwise allowed to do, simply based on his determination that there's some kind of an emergency. We've seen this with tariffs. We've seen this with the Alien Enemies Act. We've seen this with, tons of other things Trump is doing in the face of what no one would think of, Katie, as an emergency, right? The problem, and you know this as well as anyone, is that courts historically have been, to my mind, too deferential, but certainly deferential in interpreting these kinds of statutes on the theory, by the way, the not implausible theory that Congress meant to give the president a fair amount of interpretive latitude in these cases.
So is there precedent in terms of case law, even if it's dicta, meaning it's not the holding, but a discussion in the part of an opinion that defines what special conditions or an emergency nature are that would help you interpret what Section 740 is?
No, because it's never been used.
Wait. So this is the first time Section 740 has ever been invoked?
So far as we know. Trump hasn't pointed to prior examples. Well, because the reality is that, like, what Congress was worried about in 1973. So Katie, keep in mind, right? 1973 is 5 years removed from the riots of 1968. Okay. And DC was not the only major U.S. city that had urban riots in summer 1968, but the riots in DC were especially disruptive. And all but shut the city down, right, for a fair amount of time. So your Congress in 1973, right, you are a benign Congress just trying to do what makes sense from the perspective of the separation of powers.
Okay.
It's not insane that you're, worried about perhaps a mayor who is politically adverse to the current president, refusing to lift a finger to help the federal government during some kind of emergency. Like, that's, there's actually the reality that has never manifested. We've had 50 years of actually pretty decent cooperation between the DC local government and the federal government. But, the scenario that Congress was worried about, Katie, is not one that I think in retrospect we should be entirely dismissive of.
So I like to remind everybody here, and always, that an executive order is not law. It's not law, people, not law. But in this executive order declaring a, quote, crime emergency in the District of Columbia, which is what Trump has used to pretty much justify his invocation of this Section 740, he does say, though, that operational control is going to be delegated to Pamela Joe, the Attorney General of the United States. So if he's borrowing assets from Metropolitan PD, but he's putting them under the operational control of Pam Bondi, in reality, isn't the reality that she's controlling what is happening with these police officers then?
Some of them, yes. I think there's no question about that. What we don't know, Katie, is how many. I live in DC. I have plenty of friends who are on the ground, in the neighborhoods where these deployments are happening. What we're hearing is that the basic way this authority is being used is that with all of these federal law enforcement officers who are going into these random neighborhoods, they're basically sort of embedding a couple of members of the MPD with them. But isn't that their job anyway already? Doesn't MPD do that as local law enforcement? Yes. So listen, I'm not, there is no factual predicate for what the Trump administration is doing in Washington, D.C. Yeah. The problem is that the absence of a factual predicate is not necessarily a fatal legal obstacle because of how much deference Congress has baked into this kind of statute. There's a broader debate to be had about whether that deference is healthy or unhealthy. I've been arguing basically for my entire academic career that it's unhealthy. Well, especially when you have this push for a unitary executive, but keep on going. Well, not just a unitary executive. I actually would say worse than the unitary executive is a president who has such a casual relationship with the facts. Right. We've seen presidents of both parties who were much more, I think, willing to take the facts as they are, who were willing to be bound by facts they didn't like, and who did not just whip out a Sharpie anytime that they, found like a BLS report they didn't like. So the problem here is basically that we have the culmination of two different things. One is deference that Congress has given and courts have recognized for statutes like this that really has been there for a very long time. And two, a uniquely fact-indifferent president who is perfectly willing to invoke these authorities in contexts in which there's just no plausible predicate for doing so.
Okay, so hit pause for a second. This is a DC specific scenario that we are talking about. We've heard Trump threaten to do this and replicate it in places like Baltimore, Chicago, etc. But this kind of, and I call it the hijacking of the MPD, the hijacking of the local police department, though, is only happening in the DC context because of the specific section of home rule. So really, the only thing that he could do, and that's maybe our segue into National Guard, is let's talk about National Guard in the DC context, because that is also very unique to DC, but whether or not we can anticipate seeing that happen in other places, considering that bench trial that we're seeing in California right now.
Yep. So we have to get a little tricky again. So the DC National Guard, I mentioned this briefly when we started, but it's worth coming back to this. The DC National Guard is unique among every single National Guard unit in the country, including, by the way, the National Guards in the other territories, which is that only the DC National Guard is subject to the president's direct control, even when they're not federalized. Right? Meaning, if you're in the California National Guard or if you're in the Guam National Guard, your typical day-to-day status is unfederalized, meaning you take your orders from the governor. Mm-hmm. In that capacity, you are not part of the federal military. Rather, you are basically an arm of the state, or in Guam's case, the territory. DC doesn't have that. In DC, the DC National Guard is always subject to the command and control of the president. There are some very weird, quirky historical reasons why that's true. One of which is the fact that at the time Congress stood up the National Guard system, DC didn't have a local government. So there was no one else to give command and control to. But the reason why that matters, Katie, is because the president can have the DC National Guard do things when they're not federalized that he can't have any other National Guard in the country do. And so, he has the power to deploy the DC National Guard in DC without federalizing them in a way that he would not have over any other National Guard unit anywhere in the country, no matter what he says about Chicago, New York, or his other favorite cities.
Meaning he can use the National Guard in DC to do civilian law enforcement actions and conduct, which otherwise he couldn't do in another jurisdiction because of posse comitatus.
So that's the theory. Now, the Justice Department has taken that position for decades, including an internal memoranda by the Office of Legal Counsel. It's worth noting, Katie, they're not testing that theory right now. Right, that all the accounts I've seen are that the National Guard units that have been deployed in DC are only on federal property. Mm-hmm. Right. And so long as that's true, they're not even testing what you just said entirely correct. Right. They're not even testing the broadest theory, which is that the DC National Guard and the DC National Guard alone, right, could be deployed by the president without implicating the Posse Comitatus Act. The Posse Comitatus Act, of course, is the general prohibition on using federal troops for civilian law enforcement. It has exceptions, but Trump hasn't invoked any of those. And so that's really what's happening. Trump is sort of relying on these two DC-specific authorities to walk right up to the line of what he's allowed to do, maybe even in a couple of cases to cross it. But Katie, in both cases, in ways that he could never rely upon anywhere else in the country. And I think the danger here is that it looks like a precedent and it moves the Overton window and it desensitizes people to the idea that it's, a radical exacerbation to put troops on the streets. But legally, he's actually pushed every single button he's allowed to, and now he's done. And, I'm worried about the sort of the optics of this, right? Sort of, and the extent to which folks on the ground don't appreciate how special and unique the legal authorities are vis-a-vis DC and nowhere else.
What about, before we shift to California, because we've talked about posse comitatus, and that is the central issue that's on trial in California in a bench trial in federal court because of the deployment of federal troops back in June to LA. Before we go there, though, what about the embedding that we're seeing happening with Homeland Security, DHS, et cetera, in DC? We know that that has happened. Kristi Noem has actually been using that in conjunction with others, maybe Metropolitan PD, et cetera, to be able to execute certain ICE functions, certain DHS functions. I kind of feel like it's just giving more cover to them doing a lot of this illegality that we're seeing in the ICE immigration context.
So, you're exactly right to raise this. To be sort of a bit legally nuanced for a second, it's a different set of problems. It's problems. And the problems are sort of twofold. So one is, where is the legal authority, right, to use, for example, DEA officers for ICE raids? Yeah. There are legal authorities, but have they been invoked? Right? Where are the orders that allow for the repurposing of these federal law enforcement personnel? That's what we might call the facial question, right? What's allowing the surge in the abstract? And then, Katie, there are just a battery of Fourth Amendment questions raised by what all of these federal law enforcement authorities are doing in DC. I think a lot of folks saw Wednesday night that unidentified federal law enforcement personnel had set up a checkpoint on 14th Street, where they were stopping every vehicle between V and W Streets Northwest. Those kinds of checkpoints are not generally legal, right? So the Supreme Court has upheld checkpoints when they're for specific purposes, like sobriety checkpoints have been upheld. Checkpoints near the scene of an accident, right, to try to find witnesses, right? Border search checkpoints, fine, right? But just random, we're stopping everyone because we can, like, that's actually not something the Supreme Court, even this Supreme Court, has ever sanctioned. So, there's the sort of, again, the authority question, which is what's the basis for diverting all of these federal law enforcement resources into urban policing? And then there's the specific flashpoints once they're on the streets. There's one video that got a lot of play on social media of a DEA officer telling a DC resident he couldn't drink alcohol on his porch.
On his stoop, yeah.
Right?
Yeah, that was wild. DC law says exactly the opposite, which, by the way, is also highlighting how these folks aren't trained in the law that they're purportedly enforcing. So, I think there are layers of problems here, and peeling the different layers of the onion, I think, is frustrating, but it's also important. And I had said it was the last question, but I guess I had lied because this really is the last vis-a-vis DC. Let's put this issue to bed. January 6th, while that insurrection is happening at the United States Capitol, you've been on record now saying that the DC National Guard belongs to the president. In January 6th of 2021, it was still Donald Trump. So I just want to say, he could have brought that DC National Guard to the Capitol. I just want to make sure that's clear, right?
So I went back and looked. I don't remember the exact time. I should have pulled this up. I don't remember the exact timestamp, but sometime between 2 and 4 p.m. on January 6th, I tweeted that the president had command and control over the DC National Guard, that he had the power to send them in with no one's permission, blah, blah. Like, I said that. The tweet is still there.
Hey, constitutional law scholar here, just reminding you, Trump, that you could call in the National Guard right now.
No, I mean, so
we all know why he did it.
So, on the layers of how stupid and obnoxious and exasperating this whole episode is, right? The sort of the most stupid and exasperating piece of all of it is how what Trump is doing this week completely undermines one of the arguments he and his supporters had always made about why he didn't do more on January 6th, because, quote, he couldn't, unquote. That was always bullshit. Sorry for my language.
Oh, no, honey. I was about to say, somebody mark this timestamp this, because I got Steve Vladeck to say bullshit, but keep on going. It's okay. It is completely, we are salty here, so you can keep on going.
But it was, I mean, everyone who actually understands the relevant legal authorities always understood that it was bullshit, that the Speaker of the House has nothing to do with calling out the DC National Guard, that the mayor has nothing to do with calling out the DC National Guard. And by the way, Katie, even if we were wrong, parentheses, and we weren't, close parentheses, the president could have still federalized the DC National Guard, just as he could have federalized the Virginia National Guard and the Maryland National Guard.
To quell the insurrection, to quell the rebellion.
I
correct?
mean, yes. Yes. I mean, yes.
Yes.
Yeah.
It's a yes. It's a definitive yes. So,
Yes.
and that's actually a nice kind of way that we're going to very quickly, because I do want to talk about some voter election issues, but let's talk about California because we have a federal bench trial that's going on there. Again, because Trump sent in federal troops, he sent in National Guard members to LA.
Yep.
And he did not say, I am doing this under the Insurrection Act as an exception to posse comitatus, meaning I am saying that I am sending in these federal troops to quell the rebellion, the word rebellion being important here. And that is why I can use federal troops to do civilian law enforcement functions. He didn't go that far, but whether he violated posse comitatus is the central issue in that trial out in California.
Yep. Okay. So what happened and is happening in California is the more realistic and more serious precedent for the rest of the country, because those authorities are not California specific the way that the DC authorities are DC specific. And there too, I mean, as you said, the president did not, cross the Rubicon of invoking the Insurrection Act. He tried to use troops without invoking the Insurrection Act. And the question is whether they still crossed the line. The authority that President Trump relied upon in California is a very, very obscure provision in the U.S. Code. It's 10 U.S.C. Section 12406. In case you have that sitting close at hand if you're watching us at home. And what that provision basically says, Katie, is when federal troops are already deployed in some kind of emergency and they're not enough, you can also federalize National Guard troops. Trump basically tried to use that provision to surge California National Guard troops into LA to, quote, defend, unquote, right, the ICE officers who were going out on those raids. This is basically trying to sort of walk, again, right up to the line of what the precedents say you can do without invoking the Insurrection Act. So the president has the power to use the military, whether we're talking about regular troops or federalized National Guard, to defend federal institutions. He can, defend the federal courthouse in Los Angeles. He can defend an ICE detention facility.
Immigration building, exactly.
Right. Okay. That authority is fairly well settled. We can debate whether it should be, but it is. What they were doing in California, though, was saying we're not just defending the buildings, we're defending the individual ICE officers who are going into like the Home Depot parking lots. That's walking right up to the line. And Katie, what is striking about the testimony from the government's own witnesses in the trial this week is how many times they brought up not violating posse comitatus. That, like, for them, that was the line. They were
definitely pre-tried and prepared for what their testimony has to be, but keep on going.
No, but it goes back to the point, which is that for an administration that is accused often fairly of just not giving 2 cents about the law, right? Here we are, with them trying to twist themselves into a pretzel with regard to these legal authorities to avoid crossing this one line.
Well, what's interesting is, because I've been following that trial pretty closely, Major General Scott Sherman, who commanded the Guard contingent.
By the way, can we just talk about how great it is that it's a General Sherman?
Yeah, I know. I thought that too. I'm like, I wonder if anybody picks up on that. Of course you do. So he was the guy who was commanding Task Force 51, the National Guard contingent that Trump sent to LA in June. He testified that MacArthur Park raid, that they literally rehearsed it multiple times. And that's why it only took 20 minutes, which just goes to underscore the fact that it really was just a show of force, that it really wasn't there to actually effectuate some type of law enforcement or some type of plan. But here is the thing, because Judge Breyer, who is former Supreme Court Justice Stephen Breyer's brother, keeps on asking, where are the limits? Where are the limits? As in, where are the limits on the government's ability, the Trump administration's ability to do what they're doing? But this is what I wanted to say. And this is kind of crazy. So Major General Sherman kept on using the phrase constitutional exception when he was testifying. He kept on saying that the conduct, like setting up security perimeters, engaging in traffic control, detention of civilians, that these fell within the constitutional exception. And Judge Breyer is like, what the hell are you talking about? I've never heard of the constitutional exception to posse comitatus in my life. And General Sherman says, I'm not a lawyer, but it came from the chain of command. And this was the advice that was given. We were allowed to do these 4 things because it was in line with what the president was directing and what the Secretary of Defense, Pete Hegseth, was directing. And that's why Breyer kept on saying, but where are the limits? And what the hell are you talking about? I mean, they are making this up as they go along in this trial.
So, I mean, I think they are partly making this up. I think they're also basically trying to see just how much they can get away with. There is a constitutional exception to posse comitatus. It's the one we were talking about. It's defense of federal installations and federal buildings and federal property.
I'm not sure how traffic control is working, but okay.
So let me play the devil's advocate for just a half a second.
Yeah, please.
If you were sending the National Guard or the Marines, because there were Marines deployed in Los Angeles as well, you were sending the Marines out to run the 4 intersections, at the 4 corners of a federal building, I think maybe you could make the argument, the traffic control to preserve access in and out of a federal building, might get you there. But Katie, that's not what they were doing. I mean, this was not about that. They don't point to any federal buildings they were protecting. So, what we're seeing from the administration is efforts to basically use the law. And I'm going to steal a line from a Scottish writer, Andrew Lang. They want to use the law the way that a drunk uses a lamppost, which is to say for support and not for illumination. That's
beautiful.
They want to lean against the law, but not actually learn from it. And that's what we're seeing from this. So it's not that they're lawless. It's that they're basically sort of just, taking the law and twisting it to mean whatever they think they can get away with.
Which is distinctly different than tipsy coachman, which is you eventually get to the right place, but you're all kind of fakakta and drunk on the way there. Steve, then, and I'm sorry, because we are going to run out of time, and I do want to talk about election law, Calais, and others. So we'll definitely have you back super, super fast, as in like next week. But I want to stay on this issue because it's important.
Yeah.
The DC exceptions we spent a lot of time talking about, which was critically important that Trump is traveling under, or the DC authority, frankly, not even an exception, but authority that Trump is relying upon, it doesn't seem to be ripe or able to be attacked for pretense or pretext. But that's why I feel like this California trial is so important, because during the course of this bench trial, where an evidence is being taken through the course of testimonial evidence, documentary evidence, there's been all sorts of stuff that's been presented to Judge Breyer. You can attack pretense. You can attack pretext in that. So am I wrong to say that that is also one of the reasons why it's really important to look at the outcome of this bench trial in California? Because I feel like this will become a little bit of a gold standard for the lawyers that are going to fight against this administration when Trump tries to do the exact same LA playbook, but in another city.
You're not wrong at all. The LA case is much more important legally than the DC case is for everybody who doesn't live in DC. And that's a statement against interest because I live in DC. But the DC case is important for the optics and for moving the political conversation the way that the Republicans are. I mean, you've got, you've got different Republican members of Congress going on TV 6 times a day saying, hey, we're doing this in DC. We're next, New York is next. Legally, that's just a non-starter, right? And it's a non sequitur. What's happening in LA is not a non sequitur, right? That is the much more likely path toward putting federal troops on the streets of all of America's cities other than Washington, D.C. And that's why I think that case is really important. Katie, I'm going to throw in a random cross-reference to the tariffs case, because a big part of what's getting litigated in the federal circuit, the federal appeals court hearing the tariffs challenge, is also a similar sort of, are we really bound to defer when the president says it's an emergency that justifies these otherwise unauthorized, economic measures? I mean, the broader question of deference is one the Supreme Court's going to have to tackle sooner rather than later. The specific question of putting troops on the ground is much, much more at stake in what's happening this week in California honestly, than what's happening in DC, even though I think what's happening in DC is ominous and important for other reasons.
So are you willing to predict and use your SCOTUS crystal ball then that what happens with Breyer is going to make its way to SCOTUS, you think?
It's always tricky with the Supreme Court, as you know, to say that a particular case in the district court will be the case that gets to the Supreme Court first, right? There are lots of things that can happen to sort of another case comes along faster. I mean, we're waiting, for example, for the Fifth Circuit to rule on the Alien Enemies Act proclamation, which has a similar question baked into it.
Similar idea, this emergency, state of emergency, invocation, executive order energy. Exactly.
Right. So I guess I am very confident that sometime in the next 18 months, the Supreme Court's going to have at least one and probably more than one major case that turns at least to some degree on whether the president's entitled to just point at something and say it's an emergency, or say it's an invasion, or say it's a rebellion. Will it be, Newsom versus Trump, the case before Judge Breyer? Harder to say. I'm a little skeptical for various reasons, but I wouldn't, not to the point of saying no, just that too many other things could happen where some other case gets there first.
I'm wary. I mean, I wasn't kidding. I need you to come back to talk about the election stuff, but because it deals with the redistricting, which is what we're just swimming under and drowning under right now. But I'm wary about this SCOTUS for obvious executive authority reasons. This is the immunity court, right? This is, you've got immunity. And I know this is, and the thing is, posse comitatus is a criminal statute. I mean, it's just a lot.
This is not the Supreme Court I would want to decide these questions. But, right, if I, at the risk of trying to go out on a slightly cautiously optimistic note, but
we'll take it. We'll take it.
A lot can happen in 12 to 18 months. And I think, much will depend if and when this issue gets to the court for reals. Much will depend on really the political situation of that moment, which could, of course, be very, very different in, August of 26 or February 27 from what we're seeing right now.
Yeah, Kangles McDonald. You never know what happens with that guy. Steve, what just occurred to me? He loves McDonald's, doesn't he? And his name is Donald. It just occurred to me.
He's Donald McDonald's.
I don't know. I call him Kangles McDonald now. Steve Vladeck, I don't even have the words. I feel like thank you is an insufficient phrase to express to you. You are incredibly patient. And I appreciate the back and forth and the ability to really kind of fully develop these ideas. And I am eternally grateful. And I am not joking, though, that I do need you to come back so we can talk about Common Cause, redistricting, racial gerrymandering, the ability to vote. Gosh.
All the things.
All the things. But Steve, thank you so much for joining me at the Katie Phang News Channel. I'm grateful for you.
Thanks, Katie. Great to be with you.
Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.